definitely slightly stupid in terms of Zoom. Okay, so back to the keynotes. Okay, this 3 of the keynotes will be, I'll just elaborate slightly just now. I'll go through the 3 keynotes of today. Basically, the should be and should not be included in the creation of a trademark, how to enforce the trademarks effectively, and some insight to the Malaysia latest statutes, which is the Trademark Act 2019. All right, what should we have for trademarks during the creation of trademarks is basically a distinctive. That's all of us have been hearing for quite some time. A trademark should be distinctive. So here are some of our clients' examples where I personally think, from a legal perspective, are considered as distinctive. Because most of the marks here, they don't render any particular meaning or has any direct meaning or direct explanation or clarification regarding to whatever they are doing in terms of their goods and services. So these are all considered as distinctive. So put in a layman's term, which means special. So if a trademark is special, we could say it is distinctive. So another thing is that I would usually urge clients to try, if you really are unable to create names which are special, you can try to pick out your favorite animals, fruits or flowers even, which represent your trademark effectively. Here are some examples where animals and fruits has been used as a trademark, which is also very distinctive and has been registered for quite some time. All right. If you really aren't able to use anything, you may be creative and create some words or mixed and match some certain words you like and create some words which is entirely cannot be found in a dictionary. Here are some good examples which you can refer to. A meaningless word is usually the most distinctive trademark that you can have. And it will usually be very, very smooth going through registration. All right, what you should not be do, and the first thing is you should not copy another or attempt to steal from another. This I cannot stress any more importantly because until today, I still receive some query from some clients regarding whether they could register this particular trademark which derives from another country maybe. I would like to stress, even though that particular trademark is not being registered or even used in Malaysia, it is absolutely not recommended for you to attempt to register it. In relation to the reason why, I will explain it towards later of my presentation. And here are some 2 examples which you should not also is that a confusingly similar trademark. You may have not tried to attempt to register another people's trademark from another country, but it's definitely you cannot attempt to copy or mimic certain elements or features from a trademark. Here are some good examples which a person intends to mimic Starbucks and 7-Eleven. Another thing which should not appear in your trademark during creation is things which are descriptive or commonly used in the relevant trade or industry. For example, here are 3 examples which is fabricated for the purpose of this particular presentation. The first thing is the pizza place. Obviously, it tells whatever you are promoting in your area or your business, which is a place which sells pizza, which is definitely a big no for registration purposes of trademarks. Another thing is the numeral, which is 66 without any stylization whatsoever, which is also a bad mark to begin with. And last but not least is Pay Easy for a financial e-payment gateway. These are all bad examples, some examples which shows a bad trademark. So keep this in mind if you intend to use a descriptive trademark and you intend to register in the future. All right. Another trend I see in local Malaysia SME is that they attempt to monopolize marketing phrases or taglines. Here are some examples which I have found through the web, which I think would prove difficult if they intend to register it as a trademark in Malaysia. Why? I believe it's quite self-explanatory for each and every one of these examples. They basically are promoting a marketing phrase in relation to their goods and services, which is should not be found in a trademark. A trademark should serve one origin which distinguishes one business provider and another business provider in the same industry. So all of these could potentially be used by another traders or potentially proprietors, which should not serve as a monopoly rights to every single one of these phrases. Here are some really not really good examples. I have no offense intended to all of these particular brand. They basically have their own mind in relation to their marketing strategy, but this serves as a guideline in relation to if you intend to use taglines, try to be special as possible. For example, Apple's Think Different is a good thing. They do not describe phones or iPads in their taglines. Or Nike Just Do It is also a good way to start. They do not mention anything about sports equipment, sports shoes, whatnot. They just mention a tagline, Just Do It, which has nothing to do with their goods and services. All right, and some should not is, these are laid down in the Malaysian regulations. Things which should not be included in your trademark, which I believe all of the SMEs must be aware of during creation. So the first thing is features which are deemed scandalous and offensive in the community. So we are all living in Malaysia and we are a multiracial country. Certain things could be deemed scandalous and offensive towards another races or another fellow citizens in Malaysia. So basically, you should attempt to use any scandalous or offensive mark in particular Malaysia. The mark could be registrable in other jurisdictions, but may not be necessarily registrable in Malaysia, and vice versa. Okay. Another thing is you should not seek to attempt to register the name of another person, be it living or dead. If you intend to register names of a person, you should definitely obtain a consent from that particular person. If it's a deceased person, you should definitely get a consent from the direct descendant. But in general, you should not attempt to register any person's name or any entity's name without their prior consent. The third thing about that should not be appearing in the trademark is, as mentioned as earlier as Marcus during his introduction, is flags and emblems and insignias, etc. regarding Malaysia. So flags is a big no, and what else? All right, emblems of government sector is a big no as well, and any other things which you will come aware of which relates to the government authority or the federal states. Last but not least are some words or signs which are identical or similar in effect of the following, which is first thing, an indication that the trademark is a registered trademark is a big no. If your mark is not registered, you should not attempt to use the R in circle symbol. That's a big no. The second thing is the hibiscus, or we call it the bunga raya in Malaysia, which is a national flower of Malaysia. You should not use it in your trademark. Reference to the YDPA, which is the to Agong. Reference to entities owned by the federal government. And reference to ASEAN, as well as the Geneva Cross and Red Crescent. We have a lot of clients from the health industry. They would generally the trademark would generally comes with the cross or the Red Crescent sign. I'm not saying that in all of these particular signs are not registrable to begin with, but if you were to put the particular cross and crescent in its exactly original form, it will most definitely result in an adverse office action, whereby the registry would either request you to remove it or disclaim it, but the latter would be seen more unlikely, consider it is expressly prohibited under the Malaysia regulation. So if you have substantially stylized it or use another color or another shape, that would mean there's a possibility for its registration. All right, some solution for should not trademark. I have put down some examples how you should go about if you have already using some trademarks or brands which already falls under the should not category. So first thing is the stylization. Like our NBS logo, we have stylized it in a 3 simple letter, we have stylized it into a special font. So it would grant registration rather smoothly if it's a significant stylization. And abbreviations such as the BBCC, FOS, and MPH, all of these are short forms or abbreviation for a relatively descriptive trademark. For example, the BBCC stands for Bukit Bintang City Centre, FOS stands for Factory Outlet Store, and MPH stands for Malaysian Publishing House. All of these in its long form is rather descriptive, which cannot be registered in its original form. Hence, abbreviation or short form is a way to go if you want to seeking to register marks of such a nature. All right, at the end of the day, if you don't intend to do any changes to your current trademark, which are deemed descriptive or common in the relevant trade of industry, or the ultimate solution for this is basically time and usage. And under Malaysian regulation, if a particular trademark can prove that he has undergone substantial usage over time, in my experience, a time no lesser than 5 years is preferable if your trademark has been exposed in the market, and you may subsequently get it registered, provided you could convince or persuade the registry that you have undergone significant promotional activity, exposure, which resulted in gain in reputation and goodwill. Then is the consequences where you can actually register such a descriptive trademark. I hope I have not lost anybody so far, but then again, if you are lost in anywhere during my presentation, you can always jot down your questions and ask me towards later of the presentation. We have a Q&A session towards the end, all right? So fear not. And I tend to go a little bit fast because of time constraint. And you see, after I've gone through a few slides, it's already 20 minutes, all right? Let's go through. The next keynotes of the day is effective enforcement. How would a business owner effectively enforce their trademark? Do I just register a trademark and just put it aside and thinking it will grow money on its own? Definitely not. I believe most businessmen would want to know how to effectively enforce the trademark and won't result in a cancellation or even a lapse of that particular registration or their trademark IP rights. There are several ways which I have jotted down 4 of them, which is really not exhaustive. The first thing is proper and correct use by way of active commercialization. So how to commercialization, I will leave it to the respective business owner on how to commercialize their particular trademark because they know their business better than me. But I would point out certain common habits found in brand owners. So the first thing is, their common traits is the brand owner, they tend to lack of sufficient due diligence before usage of a brand. This is extremely important because even though you may like a brand, you may love a brand, it may have been following you since the beginning, but certain client tends to be, I have jotted down there 2 particular traits which is rather offensive to begin with. So I would say they are rather stubborn in a sense that when we advise them your trademark is unusable in this particular country or in this particular classification, they tend to be stubborn and insist in the filing. So it will definitely result in adverse office action. So due diligence is very important. Due diligence could mean that you could always proceed with a trademark search in the respective classes to see whether the particular trademark has been prior owned by another. The trademark search not necessarily would not limit themselves in the particular trademark register. It will also expand we do expand our search to web searches to include potential foreign owned brand, because Malaysia registry, they do reject applicants' application if the brand they suspect is owned by a foreign entity. And it is best to do the due diligence before you file your trademark. Okay, and the next thing is neglect usage until approval of application. This is the most common trait, as well as the second common trait I found in brand owner. They may have a new mark or they even have an older trademark, but they tend to limit themselves in terms of usage and marketing because they think that it may not be approved at the end of the day. But I will have to urge all brand owners, if you have such a mindset in your head, you should get rid of such a mindset. Because in order for your trademark agents or your lawyers to intend to enforce your trademarks or help you to get the trademark registered, you have to assist the respective agents or lawyers with the respective evidence which could demonstrate usage, which I've mentioned earlier on, because the usage is very important to prove distinctive. The more usage you provide, the more distinctive the trademark will become. And the usage earlier usage will rather grant you a prior right over any particular existing trademark in the register, which grants you a prior right. And Malaysia do recognize prior rights, unlike certain countries, they on a first to file basis. Malaysia is a first to use basis, whereby whoever uses the trademark first has the prior rights. Okay, and last but not least is adopt a variation differing from application. I'm very aware that there are budget constraints for certain trademark brand owners, whereby they will intend to squeeze all the elements of a single trademark into an application. Yes, you may get to trademark registered because of all the different kinds, various elements found in your trademark, but it may susceptible to certain cancellation or when it comes to proving usage, because we usually urge our client to use the trademark however you filed it. So it should mirror your registration rather than changes in variation. So this is actually a not recommended strategy for brand owners to go with the registration. Otherwise, you will not see thousands and thousands of applications owned by big companies whereby they have split every single element of the trademark to register in an individual registration. This is actually the best strategy to protect your distinctive elements in your particular trademark and not to squeeze everything into a particular application. This is a bad strategy and it may come back and bite you at the end in the future. All right. So what brand owners should do is that you should ensure zero liability prior to commercial use, not only in Malaysia, but in overseas. Even though today is the main topic, well, I will limit myself in Malaysia itself, but in relation to this particular point, a lot of big brands, they tend to venture into overseas, and most of them cannot use their original name and have forced to change their name into another name in that particular country just because there are prior registration in that particular country. I'm not criticizing that particular country's brand owner that they have bad faith application or whatever. Basically, they have the same mindset and have registered as coincidentally registered the same name. So prior due diligence and to ensure zero liability before commercial use is very important. Second thing is ensure consistency between commercial use and trademark application, which is reflects back to my points above. You should maintain a consistent usage for trademarks, because in Malaysia, one can cancel a particular trademark registration if he can prove that the trademark has not been in use for 3 years consecutively. So if your brand has not been using actively, it could be canceled by any interested party should he is interested in your brand name or trademarks. The third thing is ensure continuous usage, be it old or new trademark. Usage is very important, as I mentioned earlier, because the longer the usage, the more distinctive, and ensure usage reflect the classification registered. A lot of clients, they tend to register a lot of description under a single classification, and they would try to squeeze everything possible under everything under the sun under a single application. But as most trademark owners, they are aware there are 45 classifications, and no one classification could accommodate every single industry or every single goods and services. So you need to be very clear what is your current strategy and your future strategy before you plan to register your trademark in a particular classification. So in our experience, generally one trademark will most definitely have 2 classes, the core class and the subclass. Usually the core class would be your main goods and services. The subclass would be the supplementary classifications, which remedy whatever loopholes which are not found in your main core classification. So this is the best to keep in mind. All right, the second way I'm going to talk about is distributorship, license, and franchise. All of these 3, license and franchise, may have been the same thing in other countries, but these are definitely different in Malaysia. Bear in mind, it's definitely different in Malaysia. Now I will go through some differences and its traits via a very simple table, all right? License and franchise are different I would lump them under a single category because it's basically a license or a rights to use another people's trademark, another proprietor's trademark, conducting similar businesses. Distributorship, I would separate it in a separate column because it essentially meant the different thing with other owners. Why I would try to highlight both of these here is we have received a lot of complaints from clients whereby they have received some negative, they have received some negative feedback on the market, like a Lazada or some e-commerce platform, whereby they are unable to enforce the IP rights effectively. So I will have to clear cut the differences between these 2 first before I enter into some live examples. All right. License or franchise, basically the first thing is about controlling relationship. The licensee or franchisee and the licensor or franchisor, they have a controlling relationship whereby the licensor or franchisor controls the usage of the licensee or franchisee via certain terms and conditions and clauses, which is a rather controlling relationship. For distributorship is another story. I believe some viewers here who have signed a distributorship agreement with their distributors would have known distributorship mainly is a demand and supply relationship, whereby I simply distribute or provide or supply my goods to you, and your only responsibility is to distribute it out. I do not care how you distributed it, you just distribute it, and I won't care how you actually distribute the goods and services. That's the relationship between them. And there are lesser competition between licensees and franchisees because they are essentially selling the same things. But for distributor, there are more competition between distributors because the supplier tend to sell all distributed at the same set of pricing, and it's up to the distributors in relation to the price range change in order to compete against each other. All right. I'm not sure whether the slides will be distributed out to the registrant today, but will I, Marcus? Will the slides be distributed out? Marcus, will the slides be distributed out to the participant? The slides, will it be distributed? Yeah, okay. I will leave you to your own personal reading later in your own free time for the differences between these two, because in order for me to go through every single thing, it would take a separate sessions for it. So I will just delve through it first. The main important I want to bring out is the controlling relationship and the demand supply relationship between these two. All right. Physical enforcement of IP against wrongdoers, like you can do so via lawyer cease and desist notice and court proceedings. That's the physical one. I would not touch very much on this because it's not in my interest to go through this particular thing for the current time being. And let me go back first. And some virtual enforcement of IP against wrongdoers. I'm not saying that lawyer cease and desist notice and court proceedings could not be used against e-commerce platform like Zara, Zalora, or even Alibaba. They could be used, but due to the anonymous nature of e-marketplace, the physical enforcement limb tend to be not as effective unless you are able to procure the actual identity of the vendor or the seller. So in that sense, I would rather suggest the respective brand owner to go through the virtual enforcement of IP provided by the respective e-commerce platform, which is known as the IPR policy on social medias and e-marketplace. Some owners may be aware of this should they be dealing in e-commerce, but for those physical brand owners, they may not be aware of these sort of things. So I will give you some example. Here is an IP protection platform from Alibaba, which I screenshot. It's actually a very easy platform to use, whereby you just create your own account, you log in and launch the report, and then you need to attach the certificate of registration, that's a must, and explain and provide all the URL link and the listing which you think is infringing or counterfeiting your your products. And once they go through the entire process, it will be taken down all the listings. And all of this will be taken down rather swiftly, like less than half a year, it will be done completely, comparing to law enforcement, which takes up to a year. All right. Another thing I would like to really stress about e-commerce enforcement is dumping doesn't equals to infringing, because we have been received a lot of query asking about, can I enforce against my IP against this particular listing here? They have been selling at a price extremely lower in comparison to my selling price. These sort of things, I feel very sorry to tell you that the e-commerce platform doesn't entertain such a complaint because it is not an infringing action. And e-commerce platform, they will only take action if you can infringing or counterfeiting. If anything out of these two, they will not take any action whatsoever, as it is up to you and to take whatever action you needed against your distributor, not platform. So the venue has to be very clear. And I have screenshot the Lazada. One of the very good example which I found on Lazada is the distribution agreement. So let me read out the important point, okay? So violation of such agreement do not constitute intellectual property rights infringement, as the enforcement of agreements relating to the distribution of between the parties to such agreement. Lazada does not assist with this type of enforcement activity. So after this, I hope in the future, I will not receive any more query regarding price dumping on e-commerce platform. I'm really sorry that we MBS could not assist you to enforce against the matter which happened internally between you and your distributors. All right, so this needs to be clear. All right, finally to our final keynotes of the day, which is the Malaysian new trademark law. I'm not sure whether some viewers here has come aware that soon after the law was passed last year, and beginning cases where Adidas has already taken action against several private factory which manufacture counterfeited Adidas shoes, where they were arrested for counterfeiting, which was appeared on newspaper. I'm not sure whether some viewers have read through the articles. Well, I believe this law is actually changed for the better Malaysia. So what changes, some key point changes from a business perspective are basically 4 essential things. There are a lot of changes in the new law, but most of them are regarding procedure and some legal enforcement part. I would bring out today is some more of interest point to business owner rather than from a legal practitioner. All right, so the availability of non-traditional trademark is available. That's a good sign, whereby the scent or sound mark is now available for registration in Malaysia. The second thing is the availability of multi-classification, because if you have a trademark filed in Malaysia before, you would have known every single classes are filed in an individual application, but that's not the case anymore. You can file one particular application covering all 45 classes should you wishes. And of course, the price also times equals to the number of classes you choose. There are no special discount for a multi-class application. All right, some statistic for the day. I have checked through the registry, trademark register, up till August 2020, I believe due to the not matured system of Malaysia trademark registry, there are only 61 non-traditional trademark applications as at August 2020. So the others would include a lot of some, I'm not sure what are they trying to attempt, but I will lump all those in others. But what is the glaring is I noticed that a lot of 3D trademark actually filed in Malaysia, and there are 5% of it are actually sound mark and 15% of it is actually color mark. Of course, you were wondering how are these filed in Malaysia. So I will give an example, be patient. All right, sound mark. I noticed that Hisamitsu Pharmaceutical Co. Inc. for the Japanese company has filed their sound mark, Hisamitsu, which they describe it as sung over the sound note of 4 musical tones, E, A, E, and F sharp, which sounds like Hisamitsu, something like this. This is basically the sound mark which filed by Hisamitsu. So if you have a distinctive sound mark, which I think you should not be misused by another proprietor, you could consider a sound mark in Malaysia. Or then again, color mark. If you have a really distinctive color, it's not found amongst competitor, you could consider file a color mark as well. Like Astro has filed I'm not sure the color is magenta. That's what they think, but in my perspective, I think it's just pink. All right. This color you can see. Also, I think the grant probability of this particular color mark is rather high in my experience. Bear in mind, all 61 application is still under formality validity, so it has not been granted. None of them has been granted yet, so we have still need to see through for the rest of the year, see whether any one of them has been granted. Okay, 3D marks. Here are some examples of 3D marks filed by Crafts Food, which is a Toblerone, a unique chocolate shape. They managed, even though they have been facing some difficulties in the EU and in some other countries whereby their trademarks has been invalidated, but they still wouldn't give up. And the moment Malaysia released non-traditional, they straight away filed it in. So this is the Toblerone. And Maybank has filed the significant lion head jewelry. They have filed about 5 applications, 59, 60, 61, 62, or 4 applications in Malaysia regarding the lion head 3D, what do I call this? Jewelry, maybe? All right. Okay, the third thing which is available for Malaysian citizen is the availability of international application, also known as the Madrid filing. So the Madrid protocol, where a Malaysian application can be used as a basis of registration to shoot to numerous other member states like China, Indonesia, Thailand, Vietnam. All of these countries, you can, by way of shooting through a single application, whereby it provides the convenience of monitoring and subsequently read all other administrative action. You could just deal with the international application in Malaysia itself. You could trigger the other administrative procedure in the remaining countries. In comparison to the current situation where we need to go to a particular individual country to file the application in via the national route. All right. And the last thing is, which is my own personal favorite, is the implementation of criminal liability for offenders under the Act. So previously, the Trademarks Act did not impose any criminal liability under the former Trademarks Act 1976. It has been incorporated here through, and the Trade Discretion Act has been amended to accommodate these particular changes. So now imprisonment and or fine for bad faith application are now possible in Malaysia. I would not say for bad faith application, but I would say after the bad faith application is registered, you use it or you attempt to use it, that would only result in criminal liability, not for filing itself, yeah? Okay, so this would be the last slides of the day, I believe. So the first thing I would say about is the counter is granted under Section 99 to 108 for all criminal liability. The first thing is counterfeit or false application of registered trademark. Counterfeit is rather straightforward. You counterfeited a product by applying the particular trademark on it with slight changes and intent to sell it. That's counterfeiting. False application of a registered trademark, excuse me, it basically means you use a similar product. For example, let me see what example could I use. The bottle here. For example, a thermos bottle. You produce the same bottles, but the bottle itself does not originate from thermos, but you use the name thermos itself. So that itself is false application of a registered trademark, which is a crime under the new Act, which could be fined up to 1 million ringgit and imprisonment of not more than 5 years. So do bear in mind if you have ill intent in mind. False entries, this actually meant that in essential layman terms, basically you lie to the registry. You basically file something which is false to the registry, which is also a punishable offense under the new Act. The third thing is importing or selling a falsely applied trademark. This would apply to all those, I would say, ignorant is rather offensive, all those innocent sellers in Malaysia, whereby they wouldn't know they are selling stuff which is a registered trademark from overseas or in Malaysia. They simply import from China, import from India, import from Indonesia, from Vietnam, and basically just sell it in Malaysia. But they wouldn't know that if the mark is actually a registered trademark and you sell it without the consent, it's actually falsely applied trademark, which you are liable to be to the section of this particular Act. The last thing is false representation, which is a rather straightforward thing. As I have mentioned earlier on, if your mark is not registered, don't say it is registered. So this would be granted a false representation of a mark which is registered, which is also a punishable offense under the Act. I believe this would be the last slide. Yeah, it's the last slide, and I right on time. Thank you very much.
Thank you to our speaker for being so on time. Yeah. So I believe you've heard a lot and learned a lot from our speakers sharing. Any questions from the floor now, especially for participants in Zoom? You may type your question under the Q&A section. If you find the button at the bottom of your screen, there is a Q&A. Please click it and type your question in there. Any question?
Oh, lovely. I saw a lot of lovely comments in the section.
There are a lot of
thank you very much
to our speaker. Yeah. All right. Actually, I have a question, Anthony.
Yeah.
So just now you've spoken about the position of the criminal liability to under the new Trademark Act, right? Previously,
Yes.
such thing. So,
Yes.
and you did mention that if you falsely register a mark under bad faith, yeah.
Yep.
So, by registering it does not mean a criminal offense.
Yes, yes,
But
yes.
if you were to register something that the original owner, the original user does not register, okay, let's say now I'm a bad faith applicant, I
Yep.
apply, okay, the original owner did not apply.
Okay.
Okay, so then I use it, right? I use it. So even though the original owner did not apply, does it constitute an offense for me?
Well, it is not an offense, not in Malaysia or not in anywhere in the world for bad faith application, because there are administrative action for such an application. The criminal liability would only kicks in the moment you used the trademark to commercialize. So by following it, it's not a crime itself, but by using a trademark in the market, it is a crime itself. So you have to be very clear. You may have managed to file it, but that itself may not be a crime. But the moment you use it or seeking to sell to another, that could be a crime.
Okay.
Yeah.
So meaning the owner did not register, I register and use it, or I register it and kind of like threaten the owner.
Yeah,
then the owner can take action against me if he can prove prior use something.
Well, he need not take action against him. It's such a waste of money. Basically, he just need to take action via the administrative process to remove the trademark itself would do.
I see.
Okay. Oh, I see some question. There are some red dot there.
All right, there is a Q&A. Okay,
I can see.
By Mr. Tan Kai Chuan. If we are a distributor of a brand from overseas and it's not trademarked in Malaysia, a brand from overseas not trademarked in Malaysia, yeah?
All right.
Should we register or the overseas owner should register? If, question one. Okay, second question. If we register and we have issue with the overseas brand owner and stop transaction with them, we still apply the brand from other supplier. Is it okay? That's question two.
All right, all right. Okay, for question number one, it's not a trademark in Malaysia, should we register or the overseas ownership? Okay, it is my personal advice or my personal thinking that all trademarks should be owned by the principal company or the founder of the company. It should not be held by any distributor whatsoever, because as I mentioned earlier on, it is basically just a contractual relationship, and contracts do end. And the moment it ends, the trademark would revert back to the ownership or whatever relationship you have would revert back to the owner. So it is definitely not to be registered by a distributor. That's the first question, and we have hopefully answered your question. For second, if you did register and you have issue with the overseas brand owner and stop transacting with them, and you still apply the brand from other supplier, of course it's not okay, because the moment you manage to register it, even though he's not currently using it in Malaysia now, but it's not stopping him from using it in Malaysia in the future. So if let's say in the future, or he found a new supplier in Malaysia itself, and the Malaysia's new supplier, of course he will distribute in Malaysia, and you as a registered owner would most definitely take action against the new distributor, which is unfair to the owner and the new distributor. So of course it's not okay. I hope I answered your question.
Yeah. All right. So to sum it up, right, the principal or the owner, overseas owner should own the mark.
Yes, should own the trademark.
The distributor. Yeah.
Yes.
And then Malaysia also applies the first to use concept. Yeah.
Correct. Correct.
So if you have issue, the brand owner who did not apply in Malaysia could still, do something. Yeah.
Oh, right. I like the second question.
Okay,
there is another
question. Yes, we have another question from an anonymous attendee. Okay, earlier mentioned that it requires 5 years to get the popularity to change TM to R, TM sign to R sign, yeah? What if I want to get the R sign earlier? How the process goes? What determines when to change to R?
All right. So let me answer the final part. What determines when to change to R? That's the easier part where the moment you can change to R, there are two scenarios where you can use the R directly. One is if the mark is registered overseas, because Malaysia do recognize other overseas country which is a registered trademark. You can use the R directly, that's for sure. The second thing is once the trademark concludes its publication period in Malaysia, which is 2-month period, from the moment of it accepted. There is a 2-month publication period for public inspection or opposition. Then once the period ended, you can directly change to R. But for our company policy, we tend to advise our client, you may change to R the moment the certificate has been delivered to you. That's the safest way. But from a legal perspective, you can change to R the moment the opposition period ended and you have not received any opposition against your trademark registration. That's for the R part. But for 5 years to get the popularity, this 5 years itself is just a guideline for trademark owners which owns a really descriptive or really not distinctive trademark. But if you have a very distinctive trademark, you need not worry about the 5 years popularity or goodwill or usage. You can straight away, even you have a new mark itself, which has not been used for it's only been created for 1 or 2 days, you can file it. If the mark is a very distinctive trademark, it could ultimately get granted and straight away you can use the R. You need not gain the 5 years popularity. The 5 years popularity period is for trademark owners which owns a very descriptive trademark or a trademark which is not special enough under the Malaysia regulation. Then you may need to use the 5 years popularity to convince the authority to grant you the registration. I hope I answered this attendee. All right.
All right, thank you, Anthony.
All right.
Thanks to our participants for asking questions.
Yes.
Okay. We can accept one final question. Is there any final question from the floor?
Oh, I think there is.
Okay, yeah. Would it be possible to share this recording?
Yes, you have my consent to share this recording. There's no copyright issue.
Yes, thank you, Anthony. Yeah, okay, we will have a recording of this session and it will be possible to share to you, and it also will also be uploaded to our NBS YouTube page.
We have a YouTube page?
Okay. Yes.
All right.
To our NBS YouTube page after some time. So once it's uploaded, we will send the live to you. Yeah. And also, just now we have a query. The slides will also be emailed to participants on Zoom who registered, whom we have their email. We will email the slides to you guys. Yeah. So that is the priority. All right. Just now I have promised to,
Promise what?
Show you a promotion. Am I right?
Oh, yeah.
Yeah. So as we are coming to the end of the talk, here it goes. All right. Okay, this is
Chinese?
Oh, okay. The promotion is launched in Chinese. Let me translate it. Basically, it's a registration of trademark. So we are currently running a Merdeka promotion. Yeah, Merdeka for our Independence Day until the end of September. So for trademark registration, participants on Zoom, you will be entitled for 10% off of this trademark registration with us. Yeah, you can just quote to us our promo code FB10. FB10, just quote to us, and then we will cross-check with your registration and your inquiry. Then you'll be entitled to this discount. All right, that's it. Okay, come on, next. After this talk about trademark, NBS Mini IP Talk Tour is bringing you to the next country. It is visit Middle East. So if you have your intellectual property like patent, trademark, design, and etc. to be protected in the Middle East, if you wish to protect in the Middle East like UAE, all this country, you can join our talk to learn more, okay? It will be held on the 10th of September. It's on a Thursday, 3 p.m. Kuala Lumpur time and 11 a.m. UAE time, yeah? So please keep this in mind, and it's also posted on our Facebook page. You can check out for more information on www.facebook.com/NBSMY. So if you have any inquiry, you can Facebook message us or visit our official website on www.nbs.com.my and drop us a message, yeah? Our consultant will be free to help you. All right. So we've come to the end of the talk. Thank you very much, and thank you to our speaker for sharing his wonderful slides and talk. And thank you very much for taking your time to join our talk. Yeah. So hope to see you next time. Right? All the best
Bye.
and happy weekend. Bye bye.
Bye.